Good morning, Your Honor. My name is Franklin Cosman, and I'm appearing on behalf of DLJ Mortgage Capital, Inc., who was substituted for the original plaintiff, Fifth Third Mortgage Company, in September of 2011. Your Honor, before I begin, I'd like to reserve 5 minutes for rebuttal, if that's acceptable. This is an appeal from a residential mortgage foreclosure action which resulted in a final judgment being entered in favor of the defendant below. The final judgment found that there was no competent substantial evidence presented that Fifth Third Mortgage, the original plaintiff, owned the note and mortgage at the time the action was initiated, that there's no competent substantial evidence that Fifth Third had assigned its interests to DLJ, and no competent substantial evidence that Fifth Third adequately and appropriately complied with conditions preceding, specifically that the notice was not provided pursuant to paragraph 22 of the mortgage.
Let's start with the last one. I mean, other than the records custodian saying, hey, I found the letter in the file, what evidence is there that it was ever sent? When was it sent? Who sent it? All I saw was the records custodian said, yep, it's in there.
Yes, Your Honor. She did say that. She did testify that it was in the records that came.
How does that satisfy the requirement?
Judge, the original lender, who was the original servicer and filed the complaint, also filed the default letter with the court.
Okay, it was filed.
Right, by the original lender, original servicer, the people that sent the notice filed it with the court. So we have
but there's
that
no
filing.
Request for admissions, you received this, there's no discovery,
There was no discovery taken in the case, Your Honor. Now, the default letter was filed with the court in response to the affirmative defenses that were filed by the defendant below.
But don't you need more than that? Don't you need somebody to say, yep, we mailed it, and here's our interrogatory, or here's our deposition, or here's our admission to say, yes, it was mailed, yes, we received it? I mean, it just seems lacking to me that it's just a copy of a document that the only person testifying has no firsthand knowledge at all about any of that.
Judge, she testified as a records custodian that they relied on the records that had come from Fifth Third Mortgage in which the letter was contained. Additionally, Judge, in the trial court below, there was a motion for summary judgment that was filed. And an affidavit in support of the motion for summary judgment was signed by an employee of Fifth Third Mortgage, stating that they complied with all conditions preceding. I can give you the record citation for that if you'd like, Your Honor.
You're not arguing that that automatically makes those documents part of the trial evidence, are you?
No, Judge, they're just part of the record below. And it's our position that the trial court must take judicial notice of the record of that case.
But let's assume you're correct and the trial court takes judicial notice. What links the various entities to this particular mortgagee?
Your Honor, the original plaintiff, Fifth Third Mortgage, was named as the holder of the note. Fifth Third Mortgage, taking your position, assuming that we're correct, had an employee in support of their motion for summary judgment file an affidavit saying that all conditions preceding had been complied with, meaning that the breach letter in accordance with paragraph 22.
Stop right there. But at a trial, it is a contested issue. And while burdens may shift to come forward, you, the movement, must make a prima facie case. And that's my concern. What is there in this record to establish your prima facie case, even assuming you're relying upon the business record exception?
Well, Your Honor, we are relying on the business record exception, and that's what all lenders rely on when there are service transfers from the original lender or previous servicer, is they are entitled to rely on the business records. And pursuant to the WAMCO case, our employees, when they onboard these loans, review the complete file. It's a process that these lenders and servicers go through to make sure that the loan is actually in default, that no payments have been made.
Stop with the word process. Part of that process is someone that's competent to talk about how the documents are sent out to the debtor, correct?
Yes, Your Honor.
Is there any evidence in this record to establish that simple fact?
Your Honor, there's nothing in this record, and it's unfortunate because there was no transcript of the first portion of the trial. We had to rely on reestablishing the facts and the evidence below. After a brief recess, there was a court reporter was able to take down the second half of the trial. So we don't know exactly what was said on the first half of the trial. There was argument below that the corporate representative had testified about the boarding process, which is the whole process that the banks go through. Unfortunately, because there were some objections to what we wanted to present as the facts below, some of that information was excluded from the record. So,
The next thing that, kind of taking your points in reverse order, what is there that establishes DLJ's relationship to Fifth Third and to this note? Because Fifth Third filed the original complaint in '09, and then in September of 2011, DLJ substitutes as a party plaintiff. But okay, what is there an assignment? Is there an endorsement over on the note? What else is there other than the Fifth Third was there, and now DLJ is there? What connects the two?
there was a corporate assignment, Your Honor, that was attached to the motion to substitute party plaintiff. That assignment was reviewed by the trial judge, and on the transcript of page 21, he looked at that corporate assignment. So, and no, Judge, to answer your question about the endorsement on the note, there is no endorsement on the note because the original lender filed the note with the court.
Which happened
prior to the service
after
transfer.
the fact, right? After the complaint was filed,
Yes, Your Honor, it was filed.
in '09, the original lender didn't have the note.
Your Honor, they in the complaint they assert that they own and hold the note. They attached to the complaint, and Judge, I have to apologize. In our briefs, we assert that the note was attached to the complaint. What was attached to the complaint was a summary of the terms of the note, which indicated who the mortgagee was, who the mortgagor was, the amount of the note, the interest rate, and the property
There was
address.
a description of the note.
Yes, Your Honor.
And there was also a count saying the note's lost.
There was, Your Honor, which unfortunately.
That count, that complaint never gets amended throughout the whole process. That's the complaint that the plaintiff went to trial on.
It is, Your Honor. However, the original note, 17 days after the complaint was filed, the original note was filed by the original lender, who is named in the note. So some of the cases that are cited by the appellee are that you have to have an endorsement on a note, you have to show how you came to hold the note if you're not named on the note. Fifth Third is named in the note. They originated the loan, the original servicer. They filed the complaint. They filed the original note when it was located. The original note was introduced and accepted into evidence as Exhibit A without objection. In fact, all of the exhibits that were presented by the plaintiff below were accepted into evidence. 2 of them were objected to, but eventually those objections were overruled. It's our position that the trial court reversibly erred when it ignored competent substantial evidence that there was standing at the time the case was filed. Fifth Third was the original plaintiff, the original lender, and filed the original note. There was standing at the time of trial because of the service transfer and the substitution of party plaintiff that took place approximately 2 years prior to trial. There was never an amendment by the defendant to change his affirmative defenses that there was no standing. In fact, standing is never raised by the defendant below, that there was no standing at the time the case was filed. His motion to dismiss had three issues that had nothing to do with standing or whether or not the note was attached to the complaint. His affirmative defenses also don't raise standing or the fact that the note wasn't attached to the complaint.
So what is the best evidence that connects DLJ to the note?
Well, the best evidence, Judge, is the corporate assignment that was attached to the motion for substitution of party plaintiff, which was granted, it was not objected to. Opposing counsel didn't object to it at the trial below. And for 2 years nearly from the time of the substitution of party plaintiff, the case continued. There were no efforts to amend the complaint or amend the affirmative defenses to add a standing count as it relates to DLJ. Again, Judge, if the trial court took the time at paragraph or on page 20 of the transcript to review the corporate assignment, the court was aware of it. In 2 instances below, the trial counsel asked the court to take judicial notice of the docket. Specific items were judicially noticed, but it's our position that the court should have taken judicial notice of the entire record. And the fact that the court looked at the corporate assignment of transfer, that the court was aware that there was a transfer of ownership, asked the parties about it below, and that is sufficient.
What was the testimony about it?
I'm sorry, Your Honor?
What was the testimony about the transfer?
Judge, I'm sorry.
Is there any testimony in the record about the transfer from Fifth Third to DLJ?
Your Honor, I believe that the corporate representative testified that, just give me 1 second, I don't want to mislead the court. The transcript at page 15 indicates that Celine, who was the servicer, acquired it in October of 2011 when the service was transferred. So, Judge, it's our position, as I said, that the trial court erred below by ignoring the evidence that there was standing at the time the case was filed. The original lender filed the complaint, filed the original note, and it's unrebutted. There's no allegation or testimony opposite of that. That the DLJ had standing at the time when the case went to trial as a result of the corporate assignment, which the trial court reviewed. In addition, Judge, Florida Statute 90.202, the comments following the statute indicate that trial courts may take judicial notice of the matters referenced in the statute 90.202, whether or not requested by a party to do so. So here there were two instances where plaintiff's counsel below asked the court to take judicial notice of the docket, in particular 2 items. Florida statute allows a court to take judicial notice, and there's case law, for example, the Elmore case and the Tower Credit Corp case, that say that trial courts shall take judicial notice of their record. So for those reasons, Your Honor, we believe that the judgment below should be reversed and remanded with directions to enter a final judgment in favor of the plaintiff.
Okay, thanks.
Thank you.
Good morning. It's Greg Horowitz for Mr. Rakowski. Not surprisingly, we believe that the trial court was correct on all 3 prongs. A promissory note is a negotiable instrument. When they said it was lost at the time they filed, they had the next person who took purportedly an interest in it had to prove that in order to put on a prima facie case that they actually held the note when they filed it, because it's a negotiable instrument. If someone else held the note, they didn't have standing to foreclose. When asked, you asked, Your Honor, was there any testimony about when DLJ Mortgage, how they came to own the note? I asked the witness on page 7, line 19, okay, how is it that DLJ Mortgage Capital Inc. came to own the note? Do you know? I don't know. Okay. So, more specifically, the assignment was never asked the court to take judicial notice of the assignment. The court actually said, hey, I see an assignment, and why can't I assume that is valid, or what have you, paraphrasing. And I said, because it's not in evidence, it has to be in evidence. And the Korea case, that was a lost note case, and they put the note, they identified the note in that case, but they never put it into evidence. And Your Honor, the second DCA reversed because it has to be in evidence for the court to consider it. There was no ever a request to take judicial notice about the assignment. The other point was that the court properly held that just because someone has an acceleration letter doesn't prove it was mailed. You can prove mailing by subpoenaing Fifth Third. Tell us about your ordinary procedures for mailing under the evidence code. That's sufficient. A mailing log or personal knowledge. They never did that. And I also asked the witness specifically about standing on the date of filing. And on page 5, line 14, question, do you know when Fifth Third Bank had possession of the original note? Answer, not to my knowledge. Did they have possession of it on the day they filed this lawsuit? An objection. And then on page 6, line 13, do you know if Fifth Third Bank owned and held the mortgage on the date this case was filed? Excuse me. You don't know if Fifth Third Bank owned and held the mortgage on the date this case was filed, correct? Correct. Do you know? You don't know when they acquired the note, the original note, do you? I do not. So it was established by their witness that there was no proof Fifth Third owned the note when it was filed. They said they lost it. It's a negotiable instrument. Under the cases cited in the brief, when they plead a lost note, they have to explain it, how they had standing, and then there's no assignment in evidence, and the witness, quite frankly, said she didn't know how DLJ had an interest in it. It was unfortunate for the plaintiff in this case. They appeared to have the wrong witness present in the courtroom, and they just didn't meet their burden.
Okay, thank you.
Thank you.
Very briefly, Your Honor, if I may. Judge, on the Correa case that opposing counsel just mentioned, factually distinguishable from this case, there was a failure to admit a copy of the note in evidence in the Correa case. Here, the note, the mortgage, the breach letter, and the payment history were all admitted into evidence. So there was a lost note that wasn't admitted into evidence. Here we have the original note that was filed with the court and admitted into evidence. Your Honor, on page 8 of the transcript, the question propounded was to the trial witness, and it's fair to say you don't know if someone else owned the note on the date the suit was filed. To your knowledge, do you know who owned the note on the date the suit was filed? To my knowledge, it was Fifth Third. So we have testimony that her knowledge. He says, how do you know that? Because they're the original servicer. Here it says the origination of the loan. Judge, they originated the loan, they originated the original servicer, the note was in their name. Also, at trial.
In the actual complaint, there is no allegation that they own and held the note at the time of filing, is there?
Yes, Your Honor. Paragraph 5 of the complaint, it says that the plaintiff owns and holds the note.
There was also a count saying the note was lost.
Correct, Your Honor, but because you don't have possession of the note, doesn't mean that you, and I think ownership is kind of...
The allegation is they pled that they owned and held it, but that they didn't, but that it was lost.
But they couldn't find it, essentially, is I think the point is that the fact that you don't have the physical piece of paper in your hand doesn't mean that you don't own it and that you don't have the entitlement to enforce it. Also, just to kind of parse some words, the opposing counsel had asked the trial witness when Fifth Third acquired the loan. Fifth Third originated the loan, which is borne out by page 8 of the transcript. So there was no service transfer prior to the filing of the suit. It was very clean. The original lender filed suit. There was, it's not that it went to Chase, to Wells Fargo, to 2 other servicers before it was filed. So it would be impossible to have an endorsement on the note because the note was filed by the original servicer and owner, originator of the loan, and that to go into the court records in Charlotte County and try to put an endorsement on the loan document, I think would be a problem. So for those reasons, again, Judge, we ask that it be reversed and remanded with directions to enter a judgment in favor of the plaintiff.
Okay,
Thank you.
Thank you.